Appeals from the Crown Court. It is essential that appropriate routes of appeal should be available. An appeal process's functions serve not only to protect the defendant from a perversion of justice but also to enable uniform law development. 13.5.1 Appeals by the defendant. The applicant can appeal to the Court of Appeal, Criminal Division, against prosecution and/or sentencing. Therefore, his counsel will warn him about the prospect of an appeal at the conclusion of any case in which a crime has been found guilty. Leave to appeal. The guidelines on appeals were laid down in the 1995 Criminal Appeal Act, and in all instances, the convict must seek to leave to appeal from the Court of Appeal or a declaration that the matter is fit for appeal from the judge of the court. The idea of having to get a leave is to filter out cases that are without merit and save time for the court. The petition for leave to appeal is treated in private by a sole Court of Appeal judge, although it is possible to apply for leave before a complete Court of Appeal if he fails. It is difficult to get leave to appeal. In 2011, a single judge considered 4,606 applications, but in only 1,284 cases, less than 30%, leave to appeal was granted. Even if a defendant gets leave to appeal, that doesn't mean the actual appeal is going to be a success. Only 1/3 of offenders on the petition of prosecution is successful in their challenges. The Criminal Appeal Act 1995. The Criminal Appeal Act 1995 simplified the grounds under which the court can allow an appeal. The Act states that the Court of Appeal F shall allow an appeal against conviction if they think that the conviction is unsafe, and B shall dismiss such an appeal in any other case. Because the Human Rights Act 1998 incorporated the European Convention on Human Rights into our legislation, the Court of Appeal has adopted a broad approach to the meaning of unsafe. In particular, a conviction was held as being unsafe where a fair trial was denied to the defendant. New evidence. All additional evidence would seem to be convincing and would provide a foundation for an appeal. This must be addressed in connection with whether the evidence would have been admissible and why it was not generated at that point. Court of Appeals powers. The COA can permit an appeal by a defendant and quash the conviction. Instead, the sentence could differ from that of a lesser offense the defendant might have been convicted by the jury of. As far as punishment is concerned, on the appeal of the convict, the court can decrease but not raise it. The court can opt to reject the appeal if the appeal is ineffective. The Court of Appeal also has the authority to order a retrial of the proceedings to be tried before a different jury. It was given the power in 1988, but was not immediately exercised frequently. For example, only one retrial was requested in 1989. However, their usage has increased, ordering between 50 and 70 retrials each year. 13.5.2 Appeals by the prosecution. The prosecution previously had no right to bring an appeal against either the Crown Court decision or penalty issued. Gradually, though, Parliament has given it certain limited rights of appeal against an acquittal. For two small exceptions, the defendant cannot file an appeal against a jury decided that it is not guilty. An exception is in situations where the acquittal was the product of being nobbled by the judges or witnesses, i.e., where certain jurors are bribed or intimidated by the defendant's friends. In these cases, the Criminal Procedure and Investigations Act 1996 requires an appeal to be taken to the High Court for an injunction quashing the acquittal, given there is a real indictment for jury nobbling. Once the acquittal has been quashed, the prosecution may then commence new proceedings for the same offense. Never before has this ability been used. One more exception is where the plaintiff may demand an acquittal to be quashed because the complainant has fresh and compelling evidence. Referring a point of law. Though, in cases where the defendant is acquitted, the prosecution has a special right of reference. This is according to S36 of the 1972 Criminal Justice Act, which requires the Attorney General to refer a point of law to the Court of Appeal for the purpose of obtaining a law decision. The Court of Appeal's decision on that point of law does not affect the acquittal but creates a precedent for any future case that involves the same point of law. Against sentence. Under S36 of the Criminal Justice Act 1988, the Attorney General can seek permission to appeal an unduly lenient penalty for resentence to the Court of Appeal. Initially, this authority was only used for indictable crimes, but in 1994 it was expanded to many triable either-way offenses, so the court of the crime was conducted at a Crown Court. In a number of cases, this capacity is used each year efficiently. The amount of such referrals has recently gone up. The main problem is, how does the Attorney General learn of cases that should be brought before the Court of Appeal? In reality, each year, about 300 prosecutions are brought to the attention of the Attorney General, most of which are referred to him by the Crown Prosecution Service. It is also true for the public to contact the Attorney General's office, and in this way, a small number of cases are reported a year, usually by distressed relatives of the crime victim, who feel that the original sentence was insufficient. Parliament members will also sometimes refer cases on behalf of the aggrieved constituents to the Attorney General. Whenever a case is forwarded to the Attorney General, he will examine the trial papers and decide whether to refer the case to the Court of Appeal. In 2011, the Court of Appeal heard 118 cases referred by the Attorney General. Sentences were raised in 98 of these cases. The trial involved one convict whose term was extended from 3.5 years in prison to 11 years in prison for 2 sex offenses. 3.5.3 appeals to the Supreme Court. Both the prosecution and the defense appeal to the Supreme Court from the Court of Appeal, but it is important that the case is recognized as having a point of law of general public interest, and that the Supreme Court or the Court of Appeal be allowed to appeal. Supreme Court heard very few criminal appeals. In 2011, 12 petitions for leave to appeal were considered, but in only 7 of these, leave was granted. References to the European Court of Justice. Where a question of European law involves a dispute, any court may refer the matter to the European Court of Justice pursuant to Article 267 of the Treaty on the Functioning of the European Union. Though, in criminal cases, this is a fairly rare occurrence, as most criminal law is purely domestic and is not affected by European Union law. 13.6 The Criminal Cases Review Commission. A large number of miscarriages of justice that had not been resolved through the usual appeal system culminated in calls for a disciplinary agency. It was clear that the Home Secretary had the right to review cases and appeal them to the Court of Appeal, but incidents such as the Birmingham 6 and Judith Ward had people feeling the Home Secretary was not fully separate from Parliament. When considering the question, the Runciman Commission recommended the establishment of an independent review body to consider possible miscarriages of justice. This recommendation was implemented through the 1995 Criminal Appeal Act, which established the Criminal Cases Review Commission. Powers. The Commission has the authority to investigate possible miscarriages of justice, including summary crimes, and return cases to the courts. There has always been a challenge to the Court of Appeal for the Commission to be able to refer a case, although the Commission has a right to refer a case when exceptional circumstances occur. Furthermore, the Court of Appeal may order the Commission of Inquiry and report to the Court on any subject before it in an appeal if it feels that an inquiry is capable of helping the Court resolve the appeal. The Queen appoints the members of the Commission. At least 1/3 of them are legally qualified, and at least 2/3 have applicable criminal justice system expertise. We have about 60 support staff, triple the number commonly used for such jobs in the Home Office. Nonetheless, officers are doing most of the reinvestigation research. This is found to be unsatisfactory, as it does not necessarily make such a reinvestigation separate, although it is true to say that as a consequence of inquiries by other police forces, many of the alleged miscarriages of justice have come to light. Work. At the beginning of April 1997, the Criminal Cases Review Commission took over the inquiry into the miscarriages of justice. Although some proceedings have been recommended by the Court of Appeal and others have been found by the Commission itself, the vast majority of cases it reviews are called to its notice by victims themselves or by relatives of the defendants. Some of the first incidents it examined, such as Derek Bentley's trial, were suspected miscarriages of justice about 40 years ago. In 1953, Bentley was hanged for murder, but owing to his youth, his co-defendant, Craig, who actually fired the fatal shot, was not hanged. Several attempts have been made over the years to have the trial revived, but it was not until the Criminal Cases Review Commission took over the investigation that the matter was appealed back to the Court of Appeal. In July 1998, the Court of Appeal held that the judge's summing up at the trial was not fair and quashed the conviction. Referrals to the Court of Appeal. Through 2012, the Committee for Criminal Cases Assessment had issued more than 15,000 submissions. The Commission refers 504 appeals to the Court of Appeal, of which 461 had been considered, and in 325 cases, the sentence is quashed. Cases that attracted a lot of attention included that of Sally Clark, who, in 2003, had quashed her prosecution for killing her 2 babies after the scientific evidence appeared to be faulty. Sean Jenkins' conviction for his foster daughter's murder was quashed in 2004, also due to flawed scientific evidence. In 2012, Sam Hallam's conviction for murder was quashed. Sam, who was only 17 when convicted, had always insisted on not being at the murder scene. A review of the evidence by the Commission revealed that pictures of Sam's mobile phone showed he was not present at the attack. During their investigation into the murder, the police had failed to examine his mobile phone. Comment. The existence of the Criminal Cases Review Commission represents a major change in the old system in which only the Home Secretary had the authority to report cases to the Court of Appeal. The Home Secretary rendered very few recommendations, whereas, by 2012, more than 500 had been applied to by the Criminal Cases Review Commission. Of these, the Court of Appeal quashed some 3/4 of the sentences. In many more instances, the framework now requires justice to be done. Yet the program still has issues. To deciding to appeal a case, the Commission will acknowledge that if a reference is to be made, there is a real possibility that the judgment would not be accepted by the Court of Appeal, which ensures the Commission will second-guess what the appeal court will do. It is noteworthy that the Scottish Commission was set up after larger authority had been granted to the Commission for England and Wales. The Scottish Commission may refer a case if it considers, a. that there may have been a miscarriage of justice and, b. that a referral should be made in the interests of justice. There is a strong argument for having the Commission the same authority as the Scottish Commission for England and Wales. There are also concerns about what is required to be accepted by the Criminal Cases Review Commission in reaching a determination whether to appeal or not. There must be proof or a claim that was not brought forward at the court or on appeal. This ensures that a comparison cannot be rendered if the issue was addressed at the court or on appeal but not treated properly.